Welcome to the Department of Elementary and Secondary Education AI Literacy webinar series. This is session 5, Prioritizing People. My name is Greg Kulowiec. I'm the department's AI strategy consultant, and I'll be guiding you through part 5 of this webinar series this afternoon. So I want to start with a disclaimer around the topic that we're exploring in part 5 of this webinar series. Reference in this document to any specific commercial products, processes, or services, or the use of any trade, firm, or corporation name is for the information and convenience of the public and does not constitute endorsement or recommendation by the Massachusetts Department of Elementary and Secondary Education, DESE. Our office is not responsible for and does not in any way guarantee the accuracy of information in other sites accessible through the links herein. DESE may supplement this list with other services and products that meet specific criteria. Please be advised that this guidance document does not constitute legal advice. The Department of Elementary and Secondary Education cannot provide legal counsel to local education agencies. With that, we can now get into webinar 5. Now, before we get into the topic, content or the topic on this webinar, this archived webinar recording, we're going to start with outlining that everything we've been doing in this 6-part series aligns to the department's educational vision, and that ties to AI literacy. And that is that all students are known and valued. All learning experiences are relevant, real world, and interactive, and individualized supports enable students to excel at grade level and beyond. Now, the content we are exploring in this webinar series is derived from the AI literacy module that is available on the department's EdTech AI page. Now, there's 2 versions of this module. We have the AI literacy for educators, openly accessible one that you can click through on your own. That's the one in the middle of the screen. The one on the right with the gold seal is the certificate version that you have to complete step by step, and then you can receive a certificate of completion when you are done. Now, this course is built for educators in grades K to 12 across the Commonwealth. The purpose is to help you develop a foundational understanding of generative AI. And like we said, there's 2 versions of the course. Now, if you'd like, you can explore this openly accessible one by using the URL or the QR code provided. These links are also going to be available in the video description and video notes below. Now, all the content that we're exploring in this webinar series is derived from the core principles that are outlined in this course. We've already explored grasping the fundamentals, centering human intelligence, guiding AI by crafting skillful prompts and critiquing the output. And now we're on to the 4th principle, which is prioritizing people. The goal here is to protect the privacy, dignity, and integrity over efficiency and or convenience. So this principle here is going to be tied tightly to the way that we use the tools, student data privacy, things, regulations and guidelines and law that we should be aware of whenever we're integrating our work and ideas and potentially student work with generative AI inside of a classroom setting. Because of this topic, that called for the disclaimer in the beginning of the webinar. As we're going to be exploring student data privacy law and regulation, we are not providing legal counsel. We're kind of clarifying that this is existing regulation. This is the potential connection to generative AI, and then all guidance and final decision making should be derived from your school or district's legal counsel. So let's dig into this and explore this key idea, which is prioritizing people. AI tools can be helpful, but they should never override our professional judgment or ethical responsibilities. The key is knowing when and how to use AI in ways that align with our values and protect the people that we serve, our students, our community, our colleagues. So there's 2 driving questions that we're considering that's going to ground all the work in this part 5 of this webinar series. Could I be risking student data or privacy? And am I using AI in ways that respects others and builds trust? So one is very concrete around how does my use tie to student data privacy law, regulation, federal and state guidelines, or my school guidelines. And then driving question number 2 is more of this, maybe a little bit more of ambiguous of an idea, right? Am I using this, or do I have kind of like these internal principles about using the tools effectively to show respect for others and build trust? So how can we kind of start to unpack student data privacy? So the driving question here, could I be risking student data or student data privacy? AI tools in schools must comply with all laws that govern student data. So we have FERPA, PPRA, COPPA, and Massachusetts Student Records Regulations. We are going to explore each one of these four. Make sure that you understand what are each one of these, what is the language behind them, what is the connection to generative AI, and then how might we be able to move forward to show that we value our interaction with our students, we value student data and student privacy, and we can also still potentially use these generative AI tools in meaningful ways in an educational setting. So let's start with FERPA. This is the Family Educational Rights and Privacy Act. What's the impact here? So FERPA protects access and disclosure of student education records. Now, what's the connection to generative AI? If we're talking about student education records and protecting access to that data, what's the AI connection? And we'll pose this in the form of a question. Does your district have a list of approved AI tools that meet FERPA, COPPA, and other data privacy regulations that you can select from? If not, how do you know what is acceptable to use and safe? I think at this point, it's reasonable that we should say that all educators should be using tools that are approved by their district, approved by their school, approved by their tech department that have already been vetted to meet the FERPA guidelines, right? And if you don't have access to those tools and you're using a generative AI tool, how can we ensure that this is a acceptable use that aligns to FERPA? Let's look at COPPA next. This is the Children's Online Privacy Protection Act. What does this do? It regulates online services used by children under the age of 13. So, educators across the Commonwealth working with students in this demographic, here's the AI connection we need to consider. How are these laws interpreted in the context of AI tools, and who's responsible for ensuring their compliance? Simply because we can get access to a generative AI platform, simply because we can create an online classroom environment with a code that students can join and maybe chat with an AI tool, just because that is available to us online doesn't mean that we should be going down the path of using them if we have to abide by the Children Online Privacy and Protection Act, which regulates services that students are using who are under the age of 13. I think this also connects to the previous AI connection is, does a district have a list of approved tools that align to the Children's Online Privacy Protection Act? So I think the general consensus here is that if we are going to use these technologies, they have to be approved or vetted by a technology department, school or district, internal legal counsel. If we're going to have students under the age of 13 use these technologies, we have to make sure that these tools are in compliance with COPPA, and we have to make sure that our own internal decision makers have decided that this tool is reasonable to use with this age group. And that's simply considering the Privacy and Protection Act. This is not addressing the idea that is it reasonable to have students under the age of 13, independent of COPPA, using the tools? Is that developmentally appropriate? Are they using them in ways that they can engage with them in meaningful ways? And like we're going to talk about in the next webinar, still maintaining academic integrity. So all of these ideas do come together. We're looking at these kind of guidelines now. Let's consider PPRA. This is a Protection of Pupil Rights Amendment. What is the impact here? It governs surveys and data collection involving sensitive topics. The AI connection, how is PPRA interpreted in the context of an AI tool? And again, who's responsible for ensuring compliance? So, if students are interacting with generative AI chatbots, what type of information are they entering into these models? Where is this information being stored? Are they providing sensitive or personal information? Now, obviously, these are concerns that should be brought up and addressed well before any interaction with the tools. And again, kind of a baseline idea to consider here is that any use of generative AI, the tools must be approved and vetted by my school or district, and then make sure that folks who are making these decisions have interpreted that PPRA, COPPA, and FERPA with the regulations around age and student data privacy and sensitive information, and it all aligns to the use of this tool. And we have checked the box, green lighted it, and it's available for you to use. Let's consider the last one here, which is Massachusetts Student Record Regulations. So Mass law C 603 CMR 23.00. It's defined as it ensures parents and students' rights of confidentiality, inspection, amendment, and destruction of student records, and to assist local school systems in adhering to the law. How does that connect to AI? Utilize DESE's student data privacy training resources to strengthen staff knowledge and understanding. I think what we need to be aware of here is what is considered a student record. If a student interacts with a chatbot, is that considered student record? If a student has their work that's run through a tool that's going to check for the authenticity of student work as an AI detector, or their work is going to be provided to an AI tool to get feedback on it, does that feedback become part of student record? I think we have to be aware of these concerns and then have these concerns voiced internally in a district with decision makers that can say, hey, we're comfortable with the use of this tool at this age level with sensitive information, with student data privacy, and how it relates to student record and mass student records regulations. And then again, if all of these conditions are met and the tool is approved, then it's been determined internally in your district that you can use this platform. So there are department student records resources. And again, all of this information will be linked in the video notes below. If you have questions, need answers, or guidelines around student records resources and other laws relevant to student records, that's all available on this DESE Education Laws and Regulations page. This page will be linked below. Additionally, there are mass.gov resources about students' records, Massachusetts law, Massachusetts regulations, federal law, federal regulations. So all of these pages will be linked in the video notes below. And one other thing to be aware of is on page 33 of the Department of Elementary and Secondary Education AI guidance document, there's really helpful questions for internal leadership, administration, or kind of like AI teams to discuss. So this is an extensive document, the department's AI guidance document. But if we turn specifically to page 33, there's a number of questions here, some of which we're going to go over right now. And these would be exceptionally powerful for an internal team to guide their decision making around the use of generative AI and things that must be considered if a tool is going to be approved, if educators are going to use it, or students will use these technologies. So, key questions that we need to think about, and they're bulleted here, and I like to focus on two of them, is discuss how your district identifies and applies the laws that govern AI use, including FERPA, COPPA, PPRA, IDEA, Section 504, Massachusetts state law. How are these laws interpreted in the context of AI tools? Who's responsible for ensuring compliance? Identify a potential source of local legal counsel for issues that may fall outside of the knowledge base of the AI legal compliance lead or cross-departmental working group. So critical questions to think about and identify. And then if we go to that lower level of going deeper, additional questions for reflection, I like the second one. Discuss how teachers are supported to model legal, responsible AI use in the classroom. Educators are being given access to these tools and platforms. And we talked about the idea of transparency around use, and we're going to explore transparency. But I think it's also modeling legal responsible use about student data, protecting data, what expectation exists for disclosing tool use, limitations, protecting data, ensuring equitable access. So those are two that stand out to me. But again, page 33 of the department's AI guidance document could be exceptionally helpful to kind of navigate these challenging legal concerns. So let's now tackle the second idea. That second driving question is, am I using AI in ways that respect others and build trust? So before you uploaded pieces of text or images into an AI model, think about the information you're using and whether or not the author or owner has given permission for their work to be used as part of AI training. So whether it's a teacher taking a student sample of work and uploading it to a generative AI model to provide feedback or guidance, or it's a student taking an excerpt or a reading or an article and adding that to an AI model to help deconstruct the challenging ideas in there, whatever it might be. Did the original creator, so two questions to consider, did the original creator or subjects of the material knowingly consent to having their work used to train AI systems? And does use of this work in any way exploit the creator's labor without permission or compensation? Now, really challenging questions to consider. When it comes to the top one about their work using to train AI systems, one thing to keep in mind is that many generative AI tools that are turned on for educators in school domains, whatever technology your school or district may select, there's often education specific settings that don't take your interactions and use your interactions to train their AI systems. It kind of puts an educator or students' interactions in a walled garden. So that's something to be aware of with the top question. Not that it shouldn't be addressed, but maybe awareness. And this could be gathering information from your technology department, or if you have an AI team or administrators that are navigating these ideas, you can find out, does our use of generative AI train their larger models, these tech company models? The second question is a more challenging one. Do we have permission to take a reading that we have or curriculum materials or whatever it might be that we have access to that we want to build on top of or transform or use as data when we're working with an AI model, or use as models of content themselves when we're working with an AI model? Do we have permission? Just because we have access to it doesn't we have permission to add it into these models? So really just critical questions for you to think about, critical questions to bring back to your leadership team when determining what does meaningful and reasonable use look like when we're maintaining trust and value with the people that we're interacting with. So let's look at different examples here of like a use case and the type of data, and then considerations that we have to make. So we look at the use case on the left, or the data on the left. So private emails, text messages, other correspondence, including videos or voice recordings. The consideration: was this communication meant to be confidential? Did both parties consent to reuse of it with an AI model? So I know that oftentimes in an education setting, generative AI is used to craft emails, or higher quality emails, or more effective communication in an email environment. But are we taking threads in that email strand and then dropping that into a model to kind of determine what our follow-up should look like? And that might be a consideration to have of, did both parties agree to this? Another challenging idea is that as generative AI is increasingly turned on in the systems we already use, in our email system, in our document creation system, in our cloud storage systems, AI just kind of lives there. And we have to have all these considerations as we're going to start using these tools. So the type of data: student essay or student schoolwork, a student crafts their own original writing assignment. The consideration here: have students consented to allow their work to be accessed by an AI tool? Is the AI tool compliant with all relevant laws and regulations? So an educator taking a piece of student writing and uploading it to an AI tool that is not an approved platform, there could be some risks around student data privacy, and even just that moral and ethical concern of the student didn't agree to this. And on the other side of it, if students are writing in a digital environment, as these generative AI tools are increasingly embedded in the platforms we use, they may encounter a situation where AI feedback is being generated on the work that they're crafting in that digital workspace, in that kind of word processing digital workspace. We'd want to make sure that the leadership and the technology department in our district is ensured that the student work and the AI feedback or content that's being potentially generated on top of that work, or to provide guidance on that work, all aligns to student data privacy that we kind of already mentioned earlier in the webinar. Let's take a look at another type of data. Maybe it's a colleague's work, such as a lesson plan they created, or their SMART goals. Do colleagues understand how their work will be used? Have they agreed to this? So a colleague crafts an amazing project, lesson plan, or assignment, and we take that and drop it into an AI model and look for modifications to kind of redesign it for our classroom. Have they agreed to that? Do they understand? Are we aware of whether our work is training larger models, or are we in a closed walled garden with the AI tool that we're using in our school setting? The last one here is published articles, transcripts, radio broadcasts, transcripts from podcast episodes, or academic or scientific papers. Is the work copyrighted? Now, one thing to keep in mind: just because something is public or openly accessible, it doesn't mean it's free for us to use it in any way that we want. So maybe we found a great podcast episode and then we can rip the transcript or download the audio and drop it into an AI model and then ask the model to make some really interesting discussion questions that we're going to use in class to kind of guide our examination of that podcast episode that we all listened to. Like, yes, we can technically go through the process, but should we be doing this? And these are considerations we have to make when it comes to this idea around data privacy and trust when we're using these tools. So, disclosure, right? Generative AI is still an emerging technology, and there's no universally accepted guidelines for disclosing its use in professional settings. However, educators who use AI are in a position to model thoughtful and responsible use that includes being completely transparent about when and how AI is being used and citing it when appropriate. So there's resources available, and these three resources will be linked in the video notes below. We have the MLA handbook on how to cite generative AI according to the MLA framework. We have the APA style citation reference formatting in the resource in the middle of the page. And then we have the Chicago style manual that addresses generative AI uh, citations as well. So these three will be linked below. Again, we're really early in the emergence of this technology. Do I formally cite use cases? Do I informally have a sub kind of like a signature in my email that says this generative AI may be used? These are all things to be aware of and consider. And I think these decisions and these questions can be addressed by school or district teams that are starting to navigate how are we going to be transparent and disclose use by teacher use, by student use, by administrator or school leader use. And here's three models that we might think about. Obviously, these are addressed more towards maybe academic writing or citation and researcher writing, but it's still something we can model our own disclosure after. So here's a scenario that we're going to consider here. This world of emailing, right? I wrote my own email and then I asked AI to refine it. Do I have to disclose my use? We talked earlier about human-centered use in an earlier segment in this webinar series, this model of like human, machine, human. And I think this kind of models that as well. We wrote the email, human, then we go to the machine. I need some refinement, I need some clarity, provide some suggestions, and then we go back. As long as we go back to human on the back end and verify it, vet it, read the email. Okay, I'm comfortable with that. Do we need to disclose use? I want to add one more layer to this as well. Are we asking the tool to rewrite the email? Or are we asking the tool to read what we've already written and then provide some suggestions? Do not rewrite it. Provide some suggestions that I could then think about to do the rewriting. I think that also kind of impacts our decision making here around disclosure. So let's look at three different opinions. I think it's important to always model the disclosure of AI use. I have a postscript on my email that says, quote, this communication was created with the assistance of AI tools. The content has been reviewed and edited by a human. Being completely transparent, disclosing the potential use, not distinguishing whether AI wrote it or AI gave some concepts to consider, but it was always crafted by a human, but complete disclosure all the way on the left, opinion A. Let's take a look at opinion B. In most cases, I would say no. That would be like disclosing that you use spell check. It's just a part of how you ensure the clarity of your communication. So no need to disclose. These tools are embedded in the workspaces that we already engage in. Not necessary. Opinion C, I don't think it's necessary and might make people unnecessarily nervous if they don't understand AI or what it means. So maybe some concern emerging from opinion C. So what I'd like you to do is maybe take a minute. We're going to go back here. Maybe pause the video here and consider in this use case, whether you ask the generative AI tool to completely rewrite your original creation, or you ask the generative AI tool to provide some feedback and guidance and a handful of suggestions without rewriting, do we have to disclose? Do you land on opinion A? Absolutely. Do you land on opinion B? It's embedded in what we do. It's not necessary. Or do you land on opinion C? I think it could cause some concern. I don't want to disclose because the folks reading it or engaging with it might not understand. So pause the video for a minute and consider where do you land on this topic. Once you're done pausing, just play, and we'll pick up from there. All right, so I appreciate that you took a second to consider that idea. It is challenging, right? Disclosure, especially early on with the emergence of this technology and the arrival of the technology. I think it would be extremely impactful if a school or a department or an entire district all took a similar consistent approach of disclosure and even had an agreement on that kind of dilemma of, are we asking the tool to do the writing, or are we asking the tool to act as a writing coach or a writing partner, not doing the work but guiding us to improve our clarity of our communication? The key takeaway here: data privacy is a paramount consideration when using AI. Improper use of AI may breach critical data protection laws, student data privacy laws. You should consult your district's legal counsel for specific questions and policies related to student data privacy and the use of AI tools. We wanted to present really critical questions today. We highly encourage you to turn to page 33 of the Massachusetts Department of Elementary and Secondary Education AI guidance document. Page 33 outlines critical questions for a school or district leadership team to consider. But again, this all comes down to your district or your school's legal counsel to specifically address a lot of these concerns. So thank you for watching part 5 in this webinar series. When you're ready, you can move on to part 6, where we're going to explore AI's impacts beyond maybe some of these concrete ideas we're exploring, to think about bigger impacts on community and society and culture. So thanks again for watching, and I look forward to seeing you in the next part of this webinar series.